Good afternoon. My name is Elena Shaltsova. I am an immigration attorney from Brooklyn, New York. In today's Legally Speaking seminar, I would like to talk to you about visa revocation and what happens after once visa is revoked. A revocation of visa may occur if Department of State has information that the person was arrested in connection with, let's say, possession of a controlled substance or DUI, driving under influence. Very often it happens when the person is in a B1 or F1 status. So what really happens if one receives a notice of revocation? What it means is that one's ability to re-enter the country using the same visa now is no longer valid, meaning that if they leave the country, they will not be able to use that visa that they still have in their passport, and they will have to apply for a new visa. And now the consulate may use any relevant ground of inadmissibility to deny them the visa. But one's status in the United States should not be affected. It means that one's application to change a status from, let's say, B1 to F1 or F1 to H1 should not be affected by the revocation of the visa. It also means that a person should not be starting accumulating unlawful presence time. For example, you were in F1 status and you got arrested in connection with the possession of a controlled substance. The the charges were eventually dismissed. Before the charges were dismissed, the visa was revoked. You remained in the United States according to the expectations and plans that you'd done before. Have you accumulated unlawful presence time from the time that your visa was revoked? Well, you should not have. It means that now, when you're going to apply for a new visa, and it will be challenging to get a non-immigrant visa in this situation usually, but let's say you have a chance of an immigrant visa, the consulate cannot state that you accumulated unlawful presence time unless something else happened in your case, and let's say your service record was terminated as well, and you overstayed your authorized stay in the United States, otherwise in connection with new policies applicable to F1 status. Okay? How would you know if your visa is revoked or not? Usually you would receive a notice from a consulate via email or phone that you gave them when you filed for the visa. But at times you will not receive such a notice. The notice should be sent to you only when it's practical. That's the regulations. But receipt of the notice is not a condition for the visa to be revoked. So that's important to know. Of course, it's better to stay out of trouble and not to worry about visa revocation. But if you believe your visa could have been revoked, and very often there are policies to revoke visas in connection with the charges of possession of controlled substance or DUIs, you can check with your consulate actually if your visa is still a valid visa by emailing them, and hopefully your visa was not revoked. If it was, as I said, it should not be affecting your existing status. If you do have some negative consequences because of the revocation of the visa, like denial of the change of status application, then you probably should ask for help from an attorney to deal with those issues, because they should not be happening unless there are other situations in your case. So I hope this video was helpful and you learned a little bit about consequences for revocation of the visa, and we have more information on our website www.shaltsova.com. Thank you.